I'm Jay Factor. I'm the keyboard behind the Cheeseman-Gillard 2C58-4 handgun carry permit cases. I want to discuss the amicus brief put forward by Cheeseman-Gillard and David Jensen under the banner of CNJFO. I was involved in the original email between Cheeseman and Jensen that said, hey, if Rogers is going to get to the Supreme Court, I think it's important that we put together an amicus brief. And it's important to understand why. The Rogers case is different than the Cheeseman-Gillard 2C58-4 handgun carry cases. So Cheeseman-Gillard right now are pending in the New Jersey State Supreme Court. And then Rogers may be going to, after some ridiculous losses at the district court level, federal district court level, over bad readings of Heller, Rogers may be going to the Supreme Court of the United States. So, an amicus brief. Let me just read for you the rules of the Supreme Court. An amicus brief should bring to the attention of the court relevant matter not already brought to the court's attention by the parties and may be of considerable help to the court. An amicus brief that does not serve this purpose burdens the court, and its filing is not favored. So I think it's important to understand that the Cheeseman-Gillard case is completely different than the Rogers case. The Cheeseman-Gillard case focuses on one facet of Heller. Cheeseman-Gillard doesn't really attempt to rehash the entire Second Amendment. It doesn't want to get into the complete history of what bear arms means. Everybody knows. The court knows. The federal court knows. New Jersey knows. The federal court, the Third Circuit, and District Court D in New Jersey, and the New Jersey Appeals Court, and the New Jersey Supreme Court, and the New Jersey Attorney General, and the New Jersey prosecutors, they all took fourth grade history. They know what bear arms means. And bear arms is not limited inside the home. That would be keep arms, and they're two different things. But obviously, the prosecutors and the Attorney General of New Jersey think they know more than James Madison and George Mason, and they have determined that they don't really have to issue 2C58-4 permits. So, I'm going to read to you Heller 2821 because I think it's important. This is the basis of the Cheeseman-Gillard case. Quote, the very enumeration of the right takes out of the hands of government, even the third branch of government, the power to decide on a case-by-case basis whether the right is really worth insisting upon. A constitutional guarantee subject to future judges' assessments of its usefulness is no constitutional guarantee at all. Constitutional rights are enshrined with the scope they were understood to have when the people adopted them, whether or not future legislatures, or yes, even future judges, think that scope is too broad. New Jersey actually brags that it decides 2C58-4 permits on a case-by-case basis. So, I don't want to get into all the cases, and there's a bunch of them. Pantano, Wheeler, Borinsky, they admitted in Priest. Priest is the first one that uses it. Priest took it from Sicardi. Sicardi didn't actually utilize case-by-case determinations. But New Jersey brags that it decides 2C58-4 permits on a case-by-case basis. And this is because of the Sicardi rule. So it's important for you to understand the Sicardi rule, okay? I'm going to read that so I get it right. I can usually do it off the top of my head, but I think it's better if I read it to you. Quote, under the Sicardi rule, there must be an urgent necessity for self-protection. The requirement is of specific threats or previous attacks demonstrating a special danger to the applicant's life that cannot be avoided by other means. Generalized fears for personal safety are inadequate, and a need to protect property alone does not suffice. So that comes from Priest at page 571 in 1991. So there's three things you need to qualify for a carry permit in New Jersey. Urgent necessity. And the urgent necessity requirement is, the urgent necessity has become an animal unto its own, but the requirement is specific threats, that's plural. Not just one threat. It's plural. And in my 2008 appeals court, the judges kind of disregarded the plural nature of that. But it is plural, and believe me, when you go, if you have one threat, you're going to get shot down. Previous attacks, again, that's plural. You have to survive multiple attacks. Why is that relevant? Well, in John Gillard's case, there was an attack. And they told John Gillard he didn't qualify for a carry permit. John Gillard also had documented threats, aka specific threats. But he didn't have, apparently, enough documented threats. And I would think that a restraining order from a New Jersey court would be enough of a threat. But apparently that one restraining order wasn't enough of a threat, combined with the attack, to issue him a carry permit, which is why I say, Gillard is unique, because Gillard actually met specific threat and previous attack. He just didn't meet threats plural or attacks plural. So there really is no standard in New Jersey. I'm going to read to you what happens in, let me put some glasses on to do this. Read to you what happens in New Jersey. So like the controlling appeals court case right now in New Jersey is Wheeler. I'm going to read you two citations from Wheeler. Quote, in the context of the grid of our firearms laws, the justifiable need component of the carry permit law is best understood as accommodating, on a case-by-case basis, those who have a reason, one based on more than a generalized concern about the prevalence of crime, to anticipate a violent attack in a public place warranting lawful defensive use of a handgun. That's from In re Wheeler, New Jersey App Division 2013 at page 739. It's really interesting that Wheeler says that, because Heller says you have the right to carry weapons in case of an attack. In case of an attack and anticipating a violent attack are two different things. We go on in Wheeler, page 759. The quote, the justifiable need requirement serves the same purpose as the employment-based exceptions, but does so on a case-by-case rather than categorical basis. Thus, those who can show an objective reason, a reason other than a generalized concern about becoming a crime victim, to anticipate an attack necessitating the defensive use of a handgun, can obtain a carry permit tailored to their showing of need. Wheeler at 759. What is a categorical basis? A categorical basis is 2C58-4 permit to purchase, 2C58-4 firearms ID card. So you pass the fingerprint check, you pass the psychological background, you pass the SBI background, the FBI background. You're not an alcoholic in the investigation. You're not an alcoholic. You're not a drug user. You haven't committed any violent crimes. You haven't committed any crimes. You haven't attempted to overthrow the government. There's a couple more in there, but there is a list. That is a categorical basis. So that categorical basis would be what Scalia says in Heller on page 2822. When Scalia says, assuming Dick Anthony Heller is not disqualified from his Second Amendment rights, the district must issue him a permit and grant him a license to carry it in the home. And I want to get into that because I think that's super important, but it's gonna throw us way over time. So I will come back to page 2822 and explain that to you. But what the most important for us to take out of that is assuming Dick Anthony Heller is not disqualified for his Second Amendment from his Second Amendment rights. And so that's what the 2C58-3 background check does. It determines whether or not you have been disqualified from your Second Amendment rights. Are you a law-abiding citizen? To put it in New Jersey terms from Burton v. Sills in 1968, either you're a fit element of society, meaning you've never committed a crime and you're not an alcoholic and a drunk, drug user, that sort of thing, or you're an unfit element of society, constantly in trouble with the law, constantly using drugs, constant DWIs, or you're a rabble-rouser that is attempting to overthrow the government. So that's a categorical basis. A case-by-case basis, to use as an example, is Rogers is completely different from Cheeseman, and Cheeseman is completely different from Gillard. Let me just focus on Cheeseman and Gillard. Cheeseman is focused on the rising crime rate in the area in which he lives, and I don't want to say in his neighborhood, I want to say around his home. So on his way to work, on his way to the store, on his way to the bank, on his way to the supermarket, in the supermarket, that sort of thing. And I don't want to say a generalized concern, because Cheeseman did give specifics in his letter of need, which right there, the letter of need demonstrates it's a case-by-case basis. But Gillard was totally different. There was an attack. The person who committed the attack went to prison. There was a restraining order. There were some letters and verbal threats documented and made. So Cheeseman is decided on Cheeseman's prevalence of crime in the area in which he lives. Gillard's concern, his case-by-case determination, is the previous attack. And I say that in singular form because it's bizarre that he actually looks to have met the Sicardi rule requirements and didn't get it. So both Cheeseman and Gillard, their reason is different than Rogers. The interesting thing about Rogers, Cheeseman, and Gillard is none of them have been disqualified from their Second Amendment rights, and yet none of them are allowed to carry arms in public, and carry arms in public is just another way of saying bear arms in Second Amendment terms. So it's important for Cheeseman, Gillard to get together with CNJFO and Jensen and file the amicus brief. And I'm really right now trying to keep this thing narrow. So I'm starting kind of at the bottom of the amicus brief in section 3D. Jensen has it labeled, "The need standard is just the sort of case-by-case determination that this court disclaimed in Heller." And I think it's important, well, I know it's important because I wrote it. It's important to get that in front of Thomas. Why? Well, aside from the fact that it was a major consideration in Heller on page 2821, let me read you what Thomas writes, and which Scalia concurred with, in Freeman v. Highland Park. Okay, so this is a dissent from the denial of writ of certiorari, page 448, Freeman v. Highland Park. It's a little long, but I think instead of cherry picking, I think I should read the two paragraphs in their entirety so you understand what Thomas is talking about. The Second Amendment provides a well-regulated militia being necessary to the security of a free state. The right of the people to keep and bear arms shall not be infringed. We explained in Heller and McDonald that the Second Amendment guarantees the individual right to possess and carry weapons in case of confrontation. We excluded from protection only those weapons not typically possessed by law-abiding citizens for lawful purposes. And we stress that the very enumeration of the right takes out of the hands of government, even the third branch of government, the power to decide on a case-by-case basis whether the right is really worth insisting upon. Instead of adhering to our reasoning in Heller, the Seventh Circuit limited Heller to its facts and read Heller to forbid only total bans on handguns used for self-defense in the home. Let's go back to the second sentence. This is Justice Thomas. We explained in Heller and McDonald that the Second Amendment guarantees the individual right to possess. That's to keep. Okay? That's to keep. Possess is to keep in the Second Amendment. The Second Amendment guarantees the individual right to possess and carry weapons. Carry weapons is bear arms in the Second Amendment. Thomas just changes the verbiage to 2019, the way people talk. People don't talk keep or bear anymore. Statute law and common English usage has become possess and carry. Let's get to the last clause of that sentence. In case of confrontation. You see how different that is instead of anticipating a violent attack as for the Third Circuit in Drake? And Thomas is kind of scathing when he talks about the Seventh Circuit. Instead of adhering to our reasoning in Heller, we all know what Heller means, for heaven's sakes. But these guys want to cherry pick it. They took that last clause of the sentence from 2822, assuming Dick Anthony Heller is not disqualified from his Second Amendment rights. The district must permit him to register his handgun, that will be R2C58-3, and issue him to a permit to carry it in the home, that will be R2C58-4. Why is that carrying not confined to in the home? Because if you read the Heller case from beginning to end, and when I say that, you also have to read the dissent, there were three separate complaints in Heller. First was the trigger lock complaint. The second was the complaint that the district wouldn't let him register his handgun. And the third was that the district would not issue him a permit to carry it anywhere in the district. That's important. Go to Heller. Search anywhere in the district. I think it comes up in Breyer's dissent like that, but it comes up in the decision as well. So this is Breyer dissenting at 2853. Quote, the present suit involves challenges to three separate district firearms restrictions. The first requires a license from the district's police chief in order to carry a pistol, i.e. a handgun, anywhere in the district. See DC Code Section 224504A, 2001. See also Section 224501A, 224506. Because the district assures us that respondent could obtain such a license so long as he meets the statutory eligibility criteria, and because respondent concedes that those criteria are factually constitutional, I, like the majority, see no need to address the constitutionality of the licensing requirement. That's Breyer's dissent at 2853, explaining that one of the complaints in Heller, I'm going to say 4506, 4504 too, is a carry permit, just like R2C58-4. Here's what Heller says. This is at 2788. Quote, the District of Columbia generally prohibits the possession of handguns. It is a crime to carry an unregistered firearm, and the registration of handguns is prohibited. See DC Code 2501, 2502, 2502.02. Wholly apart from that prohibition, no person may carry a handgun without a license, but the chief of police may issue licenses for 1 year periods. See Section 4504A, 4506. District Columbia law also requires residents to keep their lawfully owned firearms, such as registered long guns, unloaded and disassembled or bound by trigger lock or similar device, unless they are located in a place of business or being used for lawful recreational activities. Section 2507. Let's go back to the beginning of 2780, the paragraph in 2788. Remember, this is Heller, okay? This is Scalia talking. The District of Columbia prohibits the possession of handguns. It is a crime to carry an unregistered firearm, and the registration of handguns is prohibited. Wholly apart from that prohibition. And I don't know what you do. Do you highlight that? Do you underline it? Do you emphasize it? Do you put it in caps? Do you put it in bold print? Wholly apart from that prohibition, no person may carry a handgun without a license, but the chief of police may issue licenses for 1-year periods. 4504, 4506. End quote in Heller. Listen, that is our 2C58-4 permit. The registering of handguns, which was prohibited, is our 2C58-4. They're two entirely different statutes. But the carry permit anywhere in the district is what 2822 told DC to issue to Heller. There was no 2C39 exemption for 2C58-3 owned handguns that you could carry it in the home. So by issuing Heller a permit to carry it anywhere in the district, I think we're talking about 2506 and 2504 in DC code. By issuing him a permit to carry it anywhere in the district, they were issuing him a permit to carry it in the home because they didn't have the 2C39 exemption. And that's important to understand in Heller. It's also important to understand one of the reasons that New Jersey is able to make this claim is because DC had acquiesced early on that assuming Heller was allowed to register his handgun, he would be allowed to get a license to carry it. They just didn't think he had the right to do either. But there is a portion of Heller that explains by which the district means he's not insane, which is basically like our 2C58-3 requirements that you can't, it's our psychological evaluation, that sheet you have to fill out on your 2C58-3 permit. It's the same sheet you got to fill out on a -4 permit. But if you pass that, DC said they had no problem issuing the permit to carry. So why is this important? Well, you have to understand that case-by-case determinations, not just case-by-case determinations on individual applications for Second Amendment permits, but interest balancing in legislation, right? Because remember, 2821 is not just talking about the judges with carry permit applications. A constitutional guarantee subject to future judgments, assessments of its usefulness is no constitutional guarantee at all. Well, the reason that we can't get a 2C58-4 carry permit in New Jersey goes back to a law review by Franklin Zimmerman called The Final Report, Causes and Commissions of Crime in 1969. Attorney General Sills was very clear in the A165 debates and in the press that as long as you were a fit element of society, he used that in the A165 debates too, also in Burton, you could qualify for a permit to purchase 2C58-3. I think it was 2A151-33 back then, and you could you qualified for a permit to carry 2C58-4, which back then was 2A151-44. Sills explained he took the concealed portion of the carry permit law out in 1966 so he could get all handguns covered under the gun control law. Prior to Prior to 1968, guns did not need serial numbers on them, and you could buy guns via mail order or go to another state. Sills explained this multiple times. He's explained it in A165 debates. He explained it in the HR 510 to the House of Representatives in 1965. He explained it in 1966 in the Dodd hearings, and in 68 explained it again in the Dodd hearings in the Senate. The juvenile delinquency hearings, which was basically what created the federal gun control law with serial numbers, and you can't buy guns out of state or mail order anymore. That was from the Dodd. That all came from the Dodd hearings. Anyway, the state police get a hold. There's a trooper killed in 68 on the turnpike down by exit 3. But he's not by a New Jersey citizen, not even by a fit element of society. The guy was from Brooklyn. He was a criminal. He was sleeping on the side of the road. He had 2 guns with him. Cop knocks on his window, sees the gun, goes to arrest him for seeing the gun on his lap. As he goes to arrest the guy's got another gun in the back of his pants, shoots and kills the cop. The state police decide no one's allowed to carry a gun in New Jersey anymore. They come up with what we now know as the urgent necessity policy. We know that much because Sergeant Klaus and Sicardi explained that it was the investigation of the state police that determined that the standards of need were changing to become more strict. When Sicardi gets to the Supreme Court, the prosecutors and Justice Jacobs must realize that the State Police Investigation Unit is not allowed to make an administrative rule like this. The only person who's allowed to make an administrative rule regarding 2C58-4 permits is the Attorney General. That's from 2C58-2.6. They realize the state police can't even make this rule, so what they do is they change it to an internal policy. That's quotes. That comes from Priest. Priest calls it internal policy in 90. Sicardi calls it the furtherance of a strict policy of assignment judges. Well, the strict policy was the policy of the investigation unit of state police, Sergeant Klaus. But they realized it's a violation of the Administrative Procedures Act, so they made it a strict policy of assignment judges. Interesting thing is, in the entire rules of the court, the policy of assignment judges is not in there, so no one knows where it is. I filed the Freedom of Information Act request and never got anything back. They told me I couldn't have it. But what happens in Sicardi is the prosecutors read Zimring's final report. Basically, Zimring's final report says it's dangerous for businessmen to have guns because if they try to stop the crime, the criminal will overpower them, steal their gun, turn the gun on the businessman, and kill them. In a nutshell. So all the police chiefs get up and testify. Guns are dangerous for individuals to have because the criminal usually steals the gun, turns the gun on the citizen, and kills or injures the citizen. If you read the decision in Sicardi, it says, as all the expert testimony indicates, issuing of a permit to Sicardi will not make Sicardi any safer and will in fact subject him to the dangers of misuse and accidental use of handguns. So that's important to understand because that's New Jersey's interest balancing. Okay, let me read, I'm going to read Wheeler for you at 742. Quote, the legislature has determined that the presence of readily accessible handguns in public places of this densely populated state presents an inherent risk of serious injury from accident and misuse. The risk of accident and misuse in public places of this state where a carry permit is required is enhanced if for no other reason than a handgun poses a greater danger in public than it would if left at home. That comes right from the police chief testimony in Sicardi. Now, let me go back to Heller 2821. A constitutional guarantee subject to future judgments, assessments of its usefulness, is no constitutional guarantee at all. Well, what is the Sicardi rule? Misuse and accidental use of handguns. That's a future judge's assessment. Not a judge of the court, a judge of the Second Amendment, a judge of the right to bear arms. The police chiefs are judging the assessment of its usefulness, meaning that whole testimony is thrown out. Misuse, accidental use, misuse is thrown out. Let me go to Wheeler at 743. Limiting the possession of handguns in public place to those who have a justifiable need for carrying them is a long-standing measure and one long understood as essential to addressing the dangers of misuse and accidental use. Wheeler at 743. That's not a long-standing measure. That came in 1971, and it came from the police chiefs. And it's been thrown out by Heller. No longer long-standing, my friends. It's gone. Wheeler again, 736. The carry permit law serves a different purpose, addressing the serious dangers of misuse and accidental use, inherent even when the person carrying a handgun is law-abiding and responsible. Cheeseman Gillard spent a lot of money to pay Jensen to turn in the amicus brief. Cheeseman and Gillard started the conversation with Jensen. I know because I was on the email, with getting this amicus brief going. So let's get back to the original question of why. The one thing you need to understand about Cheeseman and Gillard handgun carry case is that it is not about getting Cheeseman or Gillard a carry permit. It is not about getting me a carry permit. It is about getting all of you a carry permit. What has happened in other cases that have gotten close is that in the federal court level, sometimes at District D, sometimes in the Third Circuit, when the state panics that it might lose on the Second Amendment, they just turn around and issue the permit, and the case goes away. That doesn't help you. That helps the guy applying for the permit. But it doesn't help the next guy. Now the next guy needs to get a lawyer and go to Superior Court and lose. And then he needs to hire a lawyer and go to the appeals court and lose. And then he needs to hire a lawyer and go to either Federal District Court D or the state Supreme Court. It's very expensive, way more expensive than the $20 that the permit cost. It runs into thousands. It's the thousands. I know for a fact. I've seen the checks that have gone to Jensen. I have seen the costs associated with filing all the paperwork in Cheeseman Gillard in both the appeals court and the Superior Court level. The reason that Cheeseman Gillard spent money, your money, GoFundMe page money, was for all of us, was for you, me, Cheeseman, Gillard, all the fit elements of society in New Jersey. Everybody that already has a 2C58-3 and feels that they need protection outside the home are allowed to apply and qualify for a 2C58-4 without urgent necessity. We said in the Cheeseman Gillard case that justifiable need is synonymous with Heller's lawful purpose. And the core lawful purpose of the Second Amendment is self-defense. If you go to Black's Law Dictionary, look up justifiable, it just means lawful. Go to Black's Law Dictionary, look up need, it just means perfect. Lawful purpose and justifiable need are supposed to mean the same thing. New Jersey has skewed them to mean urgent necessity. New Jersey has skewed them to mean previous attacks. New Jersey has skewed them to mean documented threats. And when I say attacks and threats, I mean in the plural. If you want a 2C58-4, this is the fight to get in. Cheeseman Gillard is looking to raise money, not just for Cheeseman Gillard. We are now actively participating in getting amicus briefs into other cases with Jensen. Again, my name's Jay Factor, the keyboard behind Cheeseman Gillard. Thank you for your time.